That I will call for argument our first case, 119712, State of Kansas versus Sonny Ook.
May it please the court, counsel, Corey Call representing Mr. Ook. Chief Justice Lugar, I would request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. A couple living at an apartment building saw Mr. Ook walk into the apartment building carrying a shotgun, and then an hour or two later, residents on the floor heard an argument. He said it was more out of hand than usual between Mr. Ook and his girlfriend, Ms. Brooks. And then they heard gunshots, and Mr. Ook had shot Ms. Brooks with the shotgun. He was charged with first-degree premeditated murder. He was convicted of that charge. We raised 2 issues in the brief that the district court failed to instruct on the requested lesser of voluntary manslaughter, and that the jury was inadequately informed on the definition of what premeditation means. I'll just take them in order, although if the court has any questions, I'm sure you'll jump in. On the lesser included instruction, the analysis is does the court have jurisdiction? Is it legally appropriate, factually appropriate, and then is it reversible? As far as jurisdiction, the lesser was requested, so tick that box. Is it legally appropriate? Voluntary manslaughter is a lesser included of first-degree premeditated murder, which he was charged with, so it's that. The real issue is, was it factually appropriate, which the district court found that it was not. And if it is factually appropriate, would the jury have reversed? Reasonable probability that the jury would have reversed. So voluntary manslaughter, what we're talking about is upon a sudden quarrel. That's really what we're relying on. And what we're relying on is the evidence of a witness who lived on the same floor, who heard the couple arguing and said that the argument was more out of hand than usual. And that's the evidence that we have. The district court said, we don't know what the argument was about. So I cannot determine whether it would cause a reasonable man to lose control, which is what courts have said is need to be. But the question should have been, was there evidence of a sudden quarrel? And there was. There's evidence that these couple had quarreled and that it had gotten out of hand. The degree of that quarrel should have been left to the jury. Whether that rises to whatever necessary to mitigate the premeditation should have been a jury question.
What about the fact he's engaging in the behavior of riding his bicycle with a loaded shotgun?
Right, and that I think
is seen traveling down the street. How does that fit into the calculus of all this?
Well, I think that is evidence of premeditation, and I think I would say in the analysis that as far as where it fits, it would fit in the reversibility analysis, because I believe if we're talking about whether the instruction should have been given, then you look at the evidence in the light most favorable to the defendant of whether it would support the verdict. And I think the fact that...
So anytime there's shouting, you get a voluntary instruction.
Yeah, I think anytime there's a quarrel between the people, I don't see the problem with letting juries sort that out. I mean, that's the worst case scenario, right?
Is that our law, though? Because I think we talk about legally sufficient provocation.
That's right.
So in other words, not just any fight, not just any loud fight.
That's right.
And in this fight in particular, the testimony was it was louder than usual.
That's
but
right.
Shouting apparently was
That's
MO,
right.
So.
Which would support it different than normal. But you're right, and I believe the language from the legally sufficient provocation. I believe this is the language that you're talking about. Is that it would cause a normal man to lose control
His reason.
Of his reason. Yeah. And it seems to me that comes from that belongs in the heat of passion section. because there are two parts to it: upon a sudden quarrel or in the heat of passion. And one, necessarily in heat of passion, if you look at the plain language of the statute, it seems to me that heat of passion includes some sort of consideration of passion. Or at a minimum, it's ambiguous, and we look at what the intent of the legislature would be. What do they mean by in the heat of passion? But if you look at sudden quarrel, and to be further, I'm not saying that there's law supporting this. I'm saying this is what the interpretation should be, is that if you look at the plain language of the statute, it's sudden quarrel. And quarrel is an argument. And sudden, they qualified it. It's sudden quarrel. But there's nothing in there that the quarrel has to be an extreme quarrel or a quarrel beyond normal. If you look at the second section of voluntary manslaughter, it says, upon an unreasonable but honest belief that circumstances existed that justify the use of deadly force under sections and amendments. So there they clearly said this is an unreasonable but honest belief. They qualified that. There's no qualification of sudden quarrel, that it has to be an extreme sudden quarrel, that it has to be some sort of unusual sudden quarrel.
Do we need to adopt your version or your interpretation of the statute? Are you asserting its plain language, first of all?
Yes.
Okay. And do we need to adopt your interpretation under a plain language rubric for you to win on this point? On the, whether there's error here? Or
I
do
would
you think
say
you can win on the evidence?
I would say no. And I'm relying on, and it's a thin no, because I'm relying on the testimony that this was an argument that was more out of hand than usual. And that the jury could have said, okay, this was more out of hand. It's a jury question at that point. But that's all there is. And I think I would say that maybe I win the battle but lose the war in the sense that it's if that is the case, then when you get to reversibility, because there was a fair amount, I think it's reasonable to say, a fair amount of premeditation evidence.
Putting aside the bicycling with the loaded gun, there were
Yes.
two people who saw him standing over a prone Miss Brooks in the hallway and continuing to fire, right?
That's right, but I guess and I don't know that I'll circle back to the bicycle because I want to get to that. But as far as as I believe the premeditation, the question for that would be, did he cool off? That is one of the factors on premeditation. Is would a reasonable man have cooled off? And did in fact this defendant cool off? And the testimony was this all happened very quickly. There was an argument, there were some bangs, and then there was a commotion in the hall, and he walked out and shot. And so I don't believe the fact that they saw him the fact of lowering the gun would include an instruction on the sudden quarrel, because there wouldn't have been time for, if I'm correct, that there was sufficient evidence that the quarrel motivated the killing, then there wouldn't have been time for him to cool off. Which I believe is what you're going to.
Is that argument consistent with some of our past case law, where we basically have just said any pause that is the moment for deliberation changes it from an action that's motivated by heat of passion or sudden quarrel, either one, to be one where you had that opportunity to not react because of that emotion, but rather because of a thought?
Well, I think, and I'm not familiar with the how small those cases get in terms of, there's certainly cases where there was an argument and then a person, I think he threw her in the trunk and drove somewhere and then she died. Or there's a break. There is a time. I don't think it's inconsistent because I think the break is based upon the cooling off period. The purpose behind the sudden quarrel exception is that the why of the killing, they were motivated, they sort of lost their senses. And so as long as that motivation exists, until they've had a time to cool off from that, then, or a reasonable person would have cooled off from that, then that indication still goes. At a minimum, I think that's, again, it's a jury question. Was there sufficient time for for him to lose that? The state can certainly argue that even if there was a quarrel, by the time he had all this time to think about it, And the jury then can make the determination of, well, was it still motivated by the sudden quarrel, or had he cooled off at that point? So I think you still get the instruction. But for the jury, it may be a different question. For our purposes, I don't think it would be inconsistent with those. But again, I can't think of exactly what cases, how narrow it goes on the cases.
Is there any direct evidence, or was there any direct evidence of what actually happened in the apartment?
No, there was just that there was this argument which got out of hand, and then there was some banging, which I think was
so what we have highly summarized is the defendant on the bike with the gun going in, and then some testimony about shouting, and then the witness, the evidence about the aftermath, essentially. Is that about right?
That is correct. If I could just add in there that he rode the bike over with the gun, and then 1 to 2 hours later is when the shootings occurred.
Okay.
And so, go ahead.
My question specifically has to do with the shouting.
Sure.
Do we know it was a quarrel? I mean, I know you're characterizing it that way, but isn't shouting also consistent with being attacked with a shotgun?
It could be, right?
So is there any evidence of a quarrel or a fight? Because it strikes me that we have evidence of shouting, but is that the same as evidence of a quarrel?
I think it is evidence that a jury could determine was a quarrel. The witness who heard this testified that it was not uncommon for Ms. Brooks and Mr. Ook to argue, or to, I don't know the exact term he used, but it was not uncommon for them to have these loud shouting, and that this was worse than normal. And so I think that a jury could decide they normally fight, this is another one of those, even though we don't know exactly what they were saying.
Was there any testimony as to how long the shouts lasted prior to the bangs?
I don't recall that. My impression of it is that it was I wouldn't say short, but it wasn't a long period of time. The second issue, if I could move on to that just quickly, deals with the definition of premeditation. And the jury was given the standard definition, instruction that we give, I think, on almost all premeditation cases. Premeditation means to have thought the matter over beforehand. In other words, to have formed the design or intent to kill before the act. Although there is no specific time period required for premeditation, the concept of premeditation requires more than the instantaneous, intentional act of taking another's life. I believe, just let me say this, there's usually two things we argue up here. One is that something is wrong, and two, what you should do about it. And I feel more strongly here about that we need to change how we tell juries about this. I feel less strongly about maybe my suggestion on what I think you should do about it. But I think the problem here is that the most clear indication we give to the jury of what premeditation is by telling them what it is not. And that is necessarily imprecise. To tell them it requires more than the instantaneous intentional act. Which, don't get me wrong, we like that. We want that to be the law. But it seems to me, by telling it it's more than intentional, it's more than an instantaneous, then they're necessarily focusing on the question of, is it more than instantaneous? If the answer is yes, then okay, it was premeditation. And if you look, this court, I think, has done a pretty good job. I went through some old history as far as how we got to here, back from the original definition, which had more deliberative acts and talked about planning and scheming as part of it. And the change seemed to happen inadvertently when Johnson in 1914, the court quoted a section of the opinion which said premeditated means to think the matter beforehand, which I read as just a definitional. That's etymologically, that's what it means. But the court, even in 2014, this court said that premeditation indicates a time of reflection or deliberation. Well, that's a pretty good definition there to give the juries. And it comes up when we talk about premeditation and what we raise, well, is there sufficient premeditation here? This court has outlined factors for jurists and attorneys to discuss and consider. And seems like maybe we should tell juries that too. If this is what premeditation is, then maybe we should give that. And in Kettler, they give the five factors, which would be good.
Explain this to me. I mean, I don't get it. what you're saying. I mean, the instruction that was given in this case, the first sentence is premeditation means to have thought the matter over beforehand. In other words, to have formed the design or intent to kill before the act. There's no negative thing about that. That's an affirmative description.
That is true.
So what's
but-
wrong with that?
Well, the problem is what we're asking jurors to do is to distinguish premeditated murder from intentional murder. That's what we're trying to get. That's the purpose of this instruction, I think, is to get them to distinguish between those two. And I'm not sure that to have formed the intent to kill before the act really distinguishes between intentional, because if you intend to do something, generally you have formed the intent before the act. That's why you do the act. And so we have these others, and the others, the rest of the instruction has come about because of those very concerns, is that, well, we're not doing a sufficient job of explaining the difference between premeditation and what intentional is. And this has become even more important as the legislature has bumped premeditated up to a hard 50. So now we're looking, if for a person with no criminal history, you're looking at 3 times the minimum time. It was a life sentence. But we would ask the court find that the district court should have instructed on voluntary manslaughter, and that the jury was inadequately instructed on the definition of premeditation.
Thank you, Counsel.
Thank you.
Your Honors. Amy Aranda for the state. I would just like to point out that, as stated in the brief, we do not believe that it was factually appropriate to give the voluntary manslaughter instruction. Not based on the record as a whole. You can't isolate one sentence of one witness's testimony to determine that there was actually a quarrel.
You can actually, under our current standard, about which there's some dispute, of course, because you can count votes as well as I can. You actually can isolate one statement from one witness and say that's some evidence for an instruction.
You can, but what I'm getting at is that taking what these 2 eyewitnesses or these 2 witnesses said, I think saying that it was a little bit or it was more out of control than normal is taking that testimony that he provided out of context. Because looking back at the record, Christopher Mosby testified when asked what first caught your attention. He said it sounded like door slamming. And then he went on to say, when asked, did you hear anything else? Sounded like an argument in the hallway. Heard a male voice and a female voice. And then what did you hear next? After the slamming and the arguing, he describes hearing more bangs, which he's describing the thought process. He's trying to process, what is it that I'm hearing? I'm used to hearing this couple argue. It's normal for them. But am I hearing arguing, or what am I hearing? And then he steps out in the hallway and sees Mr. Ook standing over Mahogany Brooks, and then
That all goes to the timing question too, doesn't it? I mean,
It
'cause
does.
It sounds like those are the only 2 people who said they heard any kind of shouting or loud
Correct.
arguing. And it sounds like from what you just read us, assuming that that's more full context, that it was all pretty much simultaneous. The shouting, the banging, the shooting was all
Right, with the exception that there was a pause between, there was a series of bangs, and then they described hearing a pause, and I believe it was Mr. Smith that testified that when he looked out, he saw Mr. Ook standing over the lifeless or
prone body.
unmoving body of Ms. Brooks on the hallway floor,
And the idea of some
she shot her
bangs
again.
or shots and then more was also consistent with other witnesses at the scene, was it not?
Correct.
Yeah.
Yes.
Thank you.
So, yes, there could be sufficient evidence based off of one witness's statement, but you have to consider it in the context of what it is that they're testifying to and describing. And it's the state's position that there was no evidence that would support legally sufficient provocation, and that there was actually a quarrel. Other witnesses described that they heard muffled voices that, well, I believe it was Mr. Mosby and Mr. Smith, that they recognized the voices, but it sounded slurred, and they could not identify what was being spoken.
Or at least they didn't volunteer it.
And as pointed out earlier, it's the state's position that that was actual shooting itself. He was in the midst of shooting her and pursuing her down 60 feet down this hallway. And so,
Was there any testimony about whether the apartment door was open was there only one witness that saw her on the floor in the hallway? I thought there were two.
I believe both saw her on the hallway. One witness, I believe it was Mr. Smith, said that he saw the actual final shot that Mr. Ook shot her on when she was on the floor.
Okay. It
Mr.
seemed like
Mosby had
to me there was
retreated
one who
back.
said a silhouette and one who said the
Correct.
defendant. But was there any testimony from those two witnesses at that moment whether they noticed if the apartment door was open or shut?
I don't believe so. I don't
Okay,
recall that in the transcript, and I
Thank you.
handled this case, and I don't recall any specific testimony about the door.
Let me ask just a couple clarifying questions so I can understand the state's position. It sounded to me like you conceded that there, even though it might be thin, there would be sufficient evidence in the record for a jury to determine that there had been an argument or a quarrel, but that evidence does not rise to the level to be sufficient for any jury to conclude that it was legally sufficient provocation. Is that a correct summary of the state's position? So
If there was any evidence of
well, it sounded like you're
quarrel.
drawing a distinction between the mere fact of an argument and then saying essentially as a matter of law, the mere fact of an argument is not enough. You have
Correct.
to have more evidence to show
Correct.
that somehow that argument is like argument plus. It's an argument that gives rise to a legally sufficient provocation.
Correct. Otherwise, I believe the defendant's position would allow voluntary manslaughter instruction to be given any time that there's a situation of any kind of unkind words or argument or some kind of disagreement, and that goes against longstanding precedent with this court. And that the rest of the arguments, I think, are set forth in the state's brief. We also believe that if the court got to the harmlessness portion of the analysis, that this court could conclude that it was harmless. There was, and we've set that out in the brief, under the skip rule, and there was overwhelming evidence of premeditation. And then I'd also like to point out that we disagree with the appellant's position that the sudden quarrel cannot be qualified by the legally sufficient provocation analysis because sudden quarrel in and of itself is an emotionally charged situation. Voluntary manslaughter under those circumstances is essentially a mitigating circumstance that lowers the severity level or severity of the offense, and so there has to be logically an analysis that drives you to that mitigating circumstance. And so moving on to the second issue, as we've set out in the brief, I think the appellant is that we believe that there was nothing wrong with the instruction as given. Again, there's longstanding precedent that that is a correct statement of the law. The instruction as it was given. The instruction does clearly state what it is not, that it is not instantaneous. That would be a second degree. But it also includes the requirement that the jury find that the defendant had thought the matter over beforehand, which is reflection or premeditation. The appellant is trying to confuse the definition of intent and an intentional act with thinking the matter over beforehand, and those are mutual. Those are exclusive concepts. You can form an intent and still think the matter over beforehand.
So you're saying the word intent and the way that it was used twice in the same instruction really has a different nuanced meaning within the context of the sentence. Is that your position?
Yes, that they have to intend the act, or as contemplated, we have an instruction or definition for intentional conduct, which is to a conscious objective to engage in the conduct or cause the result. But that's not the same as the premeditation portion of the instruction that requires reflection and thinking the matter over beforehand. They're trying to muddy those two concepts into one, and the state's position is that there is no confusion. And then again, as we've set forth in the brief, there was ample evidence of premeditation. In this case, this defendant rode approximately 18 city blocks with a shotgun on a bicycle. There was no evidence, as we've asserted, of adequate provocation. Mr. Oaks shot Ms. Brooks 6 times. They found 6 spent shell casings. Dr. Mitchell testified that she had wounds to her back and her side, or entry wounds. This isn't just any firearm, it's a pump action shotgun. That required a conscious effort to move that action between each and every shot to reload a new shell into the gun. Witnesses described hearing pause or a break in time between the series of shots, and he pursued her down the hallway approximately 60 feet. And from her door, where the evidence suggested that the first shot occurred, and there was a spent shell casing inside the front door of Ms. Brooks's apartment, from that location to where her body was subsequently found and she was deceased, it was 60 feet. So,
Is there any
blood in the
evidence?
apartment? Oh, is that what you're going to ask? Was there any blood in the apartment itself?
no,
Okay.
not that I recall.
Is there any evidence of shouting or something that might be like shouting inside the apartment versus in the hallway?
I don't know that the evidence was clear. Mr. Mosby did testify when asked if he heard anything else after hearing the door, what he thought was a door slamming. He said, when asked, did you hear anything else? It sounded like an argument just in the hallway, was his response.
So the casing found inside the apartment is evidence that there probably was one shot inside the apartment or near
It
the
was-
apartment door?
This is a very tiny apartment, and I don't recall the specific distance. I'm thinking from the photographs, and I don't recall in the record if there was testimony as to how far as distance, but it was within feet of the front door,
The door to the hallway.
the door to the hallway. And there was only one entry exit.
Would the evidence be consistent of the shot coming first and the shouting coming second?
Yes. And then as we've set forth other evidence of premeditation, he shot the final shot when she was helpless. There was evidence that prior to that, as she fled down the hallway, other residents in the building testified that they heard cries for help. Mr. Oak sought no emergency medical help for Ms. Brooks, and then he attempted to flee the scene afterward. I have no further comments unless you have questions.
Any questions? Thank you, counsel.
Thank you very much.
Mr. Cole, you're reserved 3 minutes.
So the key testimony is that of Mr. Smith, and just I think the key portion is in volume 13, around 475 to 476, just so the court can read exactly what we're talking about here. As far as whether the evidence was consistent with the shot being fired first, I think it may be that the evidence is not inconsistent with that because we have so little evidence, but the actual testimony was that they heard some hollering, which later they said we had a pretty good idea this is Tyler Smith, we had a pretty good idea that it was Sony and Mahogany arguing. Mahogany would get drunk and they would argue. Sometimes it was like that. This time it seemed more out of hand. So it seemed like they were talking about and arguing. He talked about the two loud bangs they heard. And then later he heard another bang, which he identified as, he was able to tell that was a gunshot. And he was a hunter, he was a skeet shooter, he was familiar with how guns sound. So he didn't specifically testify that the earlier bangs were not gunshots. But he did specifically testify that they were loud bangs. We assumed they were door slamming. And then I heard another bang, which I identified as a gunshot. And the hollering was around the first two bangs. So that's the evidence as I see it. I would also point out that when the state was talking about the premeditation and the definition, that they used the word reflection. That there's reflection here, which is not in the instruction, and that would be good to have in the instruction. I think that would be something that jurors would help the jurors understand what premeditation is.
I have one quick question.
Yes.
How do you respond to the state's position, but I characterized it as sort of an argument plus requirement, that it's not enough to get the instruction just to demonstrate that there was an argument. It has to be, you have to demonstrate that the content of the argument would be sufficient provocation to cause an ordinary person to lose control.
I would say that interpretation is consistent with what the courts have said. I think we need to give juries more credit than that and give them first that the language of the statute says quarrel. And that I think if there's a quarrel, especially if it's out of hand, so it's something that's more of a quarrel, that we don't need to know what the quarrel was about.
Well, you just said more of a quarrel. I mean, that's what I'm zeroing in on. Is your position that you just have to have an argument? I mean, that's a very common experience that pretty much everybody has on a regular basis.
Right, and which jurors understand, right? And I think, one, that's consistent with the plain language of the statute, but also, what we're talking about here is not a sufficiency analysis. We're talking about, do we let juries determine what crime was committed?
Well, it is sufficiency analysis. I mean, at least potentially. The question is the evidence sufficient to allow a jury
Right,
to
yeah.
find for the lesser included.
Right, and I think we give the jury, if there's a quarrel,
Just on a quarrel, that's all, that's your position. All
that's
all you have
that's-
to have is a quarrel.
That is one of them, yes, and because the problem that I have, frankly, is that nobody knows what was said, and I think under the current law, if they were arguing because she put the dirty cup in the sink again, that's not good enough. I think that's what the current law is.
But
Well, it's
if we
sudden, it
don't,
might be. I mean, are we talking about content, or are we talking about, I mean, you said you're making a plain language argument.
That's right. Yeah.
Sorry,
That's
I didn't mean
yeah.
to interrupt.
no, go ahead.
Justice
You're,
Siegel,
you're,
but-
you're in the same direction.
Yeah.
I mean, you're saying plain language, so all we know, the only limitation we know from just the language is suddenness.
That's right. Yes.
That's what you're saying.
That is my argument.
And you're
then
saying content doesn't matter.
I'm saying content shouldn't matter. I don't want to mislead the court about what I think the current state of the law is.
I understand.
I think
Okay.
it could very well be the content as it stands
You're
now.
arguing for change or extension in the law.
Or to read the plain language.
But just to be clear, under your argued position, if a quarrel was sudden, even if the substance was, why did you put your dirty dish in the sink again? That's enough.
Give it to a jury and let a jury decide whether or not that qualifies for voluntary manslaughter. That's my position.
Well, other words have been defined, found not to be just, okay, everybody knows what that means. Is there any legislative intent that leads you to think that they thought this was easy? Anything, dishes in the sink, you get the instruction?
No, to be frank, I think if this court, I'm making a plain language argument, so I think we would not go to what the legislature intended. We just look at what the plain language is. If this court finds that it's ambiguous and you get into the intent of the legislature, so the current interpretation is old, and I think the correct interpretation would be that if the legislature disagreed with this court's case law, they would have changed it.
When plain language sits on top of decades, if not centuries of common law definitions, do we read that common law back into the plain language? Because I think that's what happened here. This is just a statute that codifies centuries of common law.
That's right, and I don't know. I think, as I understand it, that would still be going to, what did the legislature intend when they did this? And
I'm just asking the plain language question. Do we read, when we know that a statute is just codifying common law, but admittedly the plain language definition might be different from how common law defined it, which way do we go?
I think you go to the common law.
Other questions?
Thank you.
Thank you, counsel. Thank you to both counsel for your arguments in this case. We will now take this matter under advisement.